Hello and welcome to Talking Point. The saga over Lehman-linked investment products took a twist this week after DBS Bank, Hong Leong Finance and Maybank, which sold these complex products to retail investors, said they will compensate what they said are vulnerable investors, that is, those who are less educated and elderly. Now, other investors who felt they were missold these products as well are looking for other ways to recover their money. Some have gotten together and are considering suing the banks. But is this approach the best option for investors? What are their options and how educated is the Singapore investor on his rights? This evening we have Mr. David Gerald, President of the Securities Investors Association of Singapore, and Mr. S. Sivanesan, a partner in law firm Roddick and Davidson. Now, David, let's get straight to the point. This week, DBS came out to say that they have evidence that there was some mis-selling or that standards were not met, and that they will come out to compensate investors. Was this too little, too late?
I think yes, I agree that they could have been a little earlier with this announcement. But as you know, tremendous number of investors have gotten involved in this, and they have to therefore do their internal process, determine their exposure, as well as decide what sort of course of action they need to take. So it does take a bit of time. But yes, the collapse of Lehman too was rather sudden. Nobody expected that, right? So given all these factors, I think it has taken a bit of time. The question is, how much time is too long and too little? So I think we need to understand some of the reasons behind the late announcements, but certainly I agree that there could have been a better or earlier announcement.
Yes, because it's unfortunate now that after 3 weeks of so-called, not protests, but 3 weeks of investors getting together at Speaker's Corner, getting together to do a class action thing and, getting their voice together, that it seems that it was only after these things happened that the banks moved.
The banks too need to determine whether in fact there has been mis-selling. So the internal inquiry, which means investigations, does take a bit of time. Whether 3 weeks is too long or too little is a matter of how much evidence they have to gather before coming to a conclusion. And also, the bank, by making the statement, is admitting liability. So they need to seek advice. And they need to seek lawyers' advice, they need to seek the board's advice. So it does take a bit of time. But yes, the investors perhaps thought, and quite rightly so, they have lost their money. And so they got agitated. And it was right for the bank to therefore call them up and say that, this is what has happened and what we are doing.
Siva, now let's turn to this issue about getting together to do a class action. You're a lawyer. Do you think that this is the right approach to take?
I think what you have to realize now is that none of the banks have denied liability. They have not come up to say that we will not pay, we will not compensate. So in that sense, the door is still open for negotiation, and I think the investors should take advantage of this. If they were to get together and start a legal suit, then you can expect the banks to stop negotiations and the defenses then come up. And then you're going to go through the whole process of a legal action.
And you think that might be more costly?
I think it'll be more costly, it'll be more lengthy, and there'll be more uncertainty. Whereas now the negotiation process is open, the banks are prepared to compensate, they're looking at the various classes, so that process is ongoing. So I think this is a better route to take for now.
And if they do not want to consider going to court, a better avenue would be FIDReC. You pay $50, you've already lost a lot of money, and the tribunal is ready to hear your case. If you don't like the decision, you can walk away. The investors are not bound by the FIDReC decision, only the FIs are bound. Right. So my recommendation to investors is file your claim with FIDReC if you think that you do not want to wait for the 3-step process with the bank. Or if the bank's decision is not suitable to you or agreeable, go to FIDReC.
How about those investors who are classified as not vulnerable, not in the vulnerable category? How realistic are their chances of getting back what they've invested in the situation?
I think we have been using this phrase mis-selling so often in the market and in the papers these last few days. But there may also be a case of mis-buying. I don't know whether these investors who are less educated, less well-informed, may actually buy products which may not suit them. They may not read the prospectus, they believe in what they hear, they know a little bit and they think that's enough. So if they are going to try to place themselves in the same category as those who don't understand English, who are less educated, that's going to be difficult. And I think their chances of recovery may be different. I'm not saying that they can't get anything, but the banks need to understand how they were sold these products, whether they bought these products on their own free will. I think that's going to be the tricky part.
I think the bottom line is this, Deborah, they trusted the bank with their monies. They did not expect what actually happened, all right? And they are a group who have their rights, and therefore our recommendation is, look, you have not lost everything, go to FIDReC. If not, you still have your, as a last resort, you can go to courts. But the FIs, as he correctly pointed out, are not denying liability. So give them a chance to settle this.
Let's turn back to the consumer again, the investors. Do you find that in general, consumers do not quite understand their rights and do not understand also what they're buying? Because, well, some would say that the prospectus were way too complicated. I mean, on a previous show, the FIA said that basically it was such a complex product. It took 10 hours for a financially trained expert to read it. So how do you expect a consumer then in such a situation to say, to be fully aware of what he's buying?
The duty is on the FIs to explain. The prospectus are there because they have to have all the information for the investors to know everything about the product, but it is too cumbersome. So it is the duty on the FIs to ensure that the investors actually understand the product. The investor has to be educated. The investor must realize the risks involved in investing in the products. And it is the duty of the FI to therefore spend time explaining the risks.
I also think some of these products may not have been suitable for the retail market. And that's where people from different classes get involved, not knowing what the product is. And if the banks don't advise them or even explain a little bit more, that's the danger.
If you ask me, these products should not have been made available to the old, the uneducated, and those who are not in the game of investment.
Actually, but if you talk about it, it's not suitable for the retail market. In other words, they shouldn't be sold at the banks, at the counters in front.
I agree with you. I mean, these products, sophisticated products, are not for the mass market, It's for the sophisticated investors, institutional investors, high net worth investors, and those who really understand the prospectus, those who can appreciate the risks. So education is the way to go. I think if investors want to get involved in this kind of products, they have to seek education.
Where can they get this education?
SIS and there are others. Money Sense is organizing and will be organizing programs, and SIS will definitely have a number of programs for investors to understand these products come 2009.
Do you think the banks would have learned a lesson from this and not then sell these products either?
I think everybody's learned a lesson. I think the banks have learned that in a crisis like this, you need to act a bit better, a bit faster, information must be more forthcoming. But I think the investors have also learned that if you don't understand the product, nobody's forcing you to park your money. You don't have to buy these products or deposit your money in these complex products.
And also it's time for a code of conduct for those who sell these products.
Yeah.
Let's everybody know what the code of conduct is. Let the investors acknowledge that they have been correctly advised and the risks explained. Then we won't have all this hoo-ha.
All right, thank you very much, both of you, for coming and joining us this evening. Again, investors need to be clear and remember to understand what they are buying, as we've concluded. And if they feel they have been misled, they also need to understand their rights and what they can do to get back their money. Tell us what you think and email us at talkingpoint@channelnewsasia.com. Join us again next Sunday. Good night.